8. Guardianship. Though the state may be looked upon as the ultimate parent, it is sometimes necessary, because of various circumstances, for a court to appoint an individual to assume control of a child or of another individual. Guardianship is the legal term, the relationship whereby one person is entrusted by law with the care of the person or property, or the person and property of another. It implies protective authority over one who, due to his age or some other cause, is unable to look after himself. The person under guardianship may be a minor, a spendthrift, or a person non-composed mentis. Guardianship under the feudal system, in some form or other, guardianship has existed from very early times. Under the feudal system in England, the baronial lords imposed certain restrictions on the vassals who were required to give military service, thereby obtaining revenue, by means of an arrangement called guardianship and chivalry. If a male heir was under 21 or a female heir was under 16 at the death of the father, the lord was entitled to take the property into his possession and appropriate all the profits of it during the minority of the ward, on the ground that it was a reasonable compensation for the services which the minor, because of his age, could not render. The lord also had the right to bring about a suitable marriage and appropriate whatever he could for this service. If the ward refused to pay him for this service, he could recover from the ward's property. If the ward married without the lord's consent, he could demand a still larger forfeiture than if he brought about the marriage. This form of guardianship applied to military tenure only and was abolished by statute in 1660. Guardianship in socage was another vagary of the feudal system and arose when an infant acquired lands by descent which were held in socage. That is, the tenants of the land were obliged to give a certain portion of the crops, or to plow the lord's land when the infant was under 14. When he became heir to the land, it was given to his next of kin who could not possibly inherit from him. And this relative had authority over the person of the heir, his land, and such property as crops and timber which had been cut. When the infant became 14, he could choose his guardian. Testamentary Guardianship. After guardianship in chivalry was abolished, a father, who was the natural guardian, was permitted, either by deed or will, to name a guardian for his child, and this guardian acted during the child's minority. This emphasis upon the power of a father shows that common law, a mother did not have equal rights with the father in the guardianship of their child. A person appointed in this way by the father was called a testamentary guardian. Testamentary guardians can be appointed today, and some states require no judicial confirmation, while in others, if a testamentary guardian has been nominated, the person has to qualify. That is, the appointment is subject to the probate of the will and to the approval of the court. In addition, the remaining parent must have notice before the appointment is made. Statutory Guardianship. In England, the Court of Chancery had jurisdiction over the person and property of infants. In this country, the courts of equity took over this function quite early. Today, special courts such as probate, surrogate, or orphans courts have jurisdiction, and the judges of these courts have the power to appoint a guardian over the person and the estate of infants. These guardians are given the legal term of statute guardians because their powers and duties are controlled by state statutes. These correspond to the Chancery Guardians of England. Guardian ad litem. Sometimes a person assumes the right to act as guardian without any legal authority, and if there is property or if civil rights are violated, he is held to account just the same as a legal guardian would be. If there is no legal guardian or anyone acting in that capacity, the court can appoint a guardian ad litem to prosecute or defend for an infant in any suit in which he is involved. For if he has no guardian, there would be no one to defend his rights, as he cannot appear in person. The duties extend only to the particular suit in question. A guardian ad litem is often appointed in adoption cases. If neither parent is living and there is no guardian or near kin to give consent, the court can appoint a suitable person to act as guardian ad litem and consent to the adoption. This guardian has no authority beyond the adoption proceedings. Guardianship, a trust relationship. As we know that the Chancery Court, which was based on justice and equitable treatment, had the power to appoint a guardian, we can conclude that the best interest of the child was of paramount consideration. Though the father's wishes were usually respected, the court had plenty of authority to appoint a suitable person even against the wishes of the father. The status of a guardian is one of personal trust, and the relationship is similar to that of trustee as well as of parent, though the guardian has no right to his ward's services or earnings. Guardianship cannot be assigned, though the relationship may be terminated by the resignation of the guardian. The statutes of many states allow institutional guardianship, by a home or organization incorporated under the laws of the state, but judges in some of these states appoint an individual only, believing that the relationship should be a personal one and not merely a perfunctory arrangement. 2. Infant's right to choose. As previously stated, at common law, if the infant was over 14, he had the right to choose the person whom he would like as guardian. This is usually true today, and unless a person is unsuitable, the judge does not have arbitrary powers. In a Connecticut case, a minor over 14 petitioned for a guardian who was not approved by the judge, and she was told to choose another 8. She refused to do this, and the judge appointed someone. She brought suit to remove the person, and on appeal the Supreme Court held that the judge did not have the power to appoint a guardian on her refusal to choose a second person when the first one was suitable. The welfare of the minor is paramount, and if a guardian is unsuitable, a judge has sufficient authority to protect the child. Jurisdiction restricted by domicile. The domicile of the infant, instead of the residence of the petitioner, determines the question of jurisdiction. Though when both are in the confines of one state, the jurisdiction is usually either in the county where the child is living or where the petitioner resides. A court in one state has no jurisdiction over an individual in another state, and after the guardianship relationship is established, the domicile of the ward follows that of the guardian. The guardianship is good only in the state where the appointment is made unless it is recognized as a matter of comity by a court in another state. Sometimes, in order to settle a large estate or to provide for a runaway child who has gone into another state, a temporary guardianship is granted in view of the one already existing in the state of the domicile. In a case which involved a runaway girl from New Hampshire, a probate judge in Massachusetts recognized the appointment of a New Hampshire guardian and granted her a temporary guardianship in Massachusetts. The guardian then had the right to bring her ward back to her own state. The welfare of the child. The court has the right to restrain a guardian from moving a ward to another state if it is not for the best interests of the child. An example of this often arises in divorce cases when the custody is given to a third party. If it is not for the best welfare of the child to live a part of the time with either one parent or the other who is outside the state, the guardian, with the approval of the court, can refuse to allow this. This is analogous to the situation which arises when a person, who is without legal authority, has acted in the place of a guardian for many years and is suddenly confronted by a parent who appears to claim the child. We are all familiar with a situation of this sort, and the decisions of the courts have not been uniform. Sometimes the court gives the custody to the parent because of the parental tie, and at other times to the person who has given years of care, motivated by love for the child. The decisions hinge on a consideration of what is best for the child, duties and powers of the guardian. While guardianship may entail a financial responsibility, this is not necessarily true. A guardian may have control of the person only and be under no personal obligation to support the ward. But if the child has an estate, the guardian acting under the court has the responsibility of administering the estate also. The following illustrates this. An illegitimate child who was born in Massachusetts was brought to New Hampshire for care, as his mother's residence before her death was in that state. The father wished to adopt his son, but as his wife would not consent, he became guardian and provided for the boy's support in a boarding home. Later, when the father was killed in an accident, another guardian was appointed to look after the boy and administer the estate which his father had willed to him. This was used by the guardian for the child's board, care, and education until he was old enough to look after himself. A guardian's first duty, like that of a parent, is to maintain and educate his ward in a manner appropriate to the ward's income, or, if the child has no estate, to plan otherwise for his maintenance and education. As a guardian is not liable personally for the support of his ward, the law implies no promise that he will pay for the necessities of life. One state holds that the guardian has no authority to make advances from his own means for the ward, and if he does this, he cannot recover when the ward becomes of age. 4 decisions are not in agreement as to whether or not a guardian may collect board and clothing if the child is taken into the guardian's own family. While a guardian has a great deal of discretionary power, he is expected to use judgment, as well as care and honesty, in the management of the estate which he holds as trustee for his ward. The court is primarily interested in protecting the rights of the child or ward, and the statutes prescribe definite conduct which the guardian must follow. If he fails in any respect, the court can remove him. A guardian is required to give a bond with security for the faithful performance of his duties, and even when there is no property, a nominal bond is usually necessary. A guardian and his sureties are responsible for all the property coming into his hands, so there must be a fair and just appraisal of the estate by a disinterested party. He has the right to invest, to lease real estate during the minority of the ward, and sometimes to sell this as well as personal property with the permission of the court. He must keep the real property in repair and pay the taxes on it, and if some of this property is in another state, he usually has to file a certificate of appointment as guardian before he can transfer the property. Many states prescribe how the funds of a ward can be invested, and by this means try to ensure against speculation. In states which are without such statutes, investments in government bonds and real estate mortgages have the sanction of the courts. A guardian is responsible for losses from investments, even though he acted with good intentions. But if there are benefits instead of losses, the ward may claim these. If the guardian occupies property of the ward, he is liable for rent, also for any depreciation caused by his lack of care. If he sells real estate, the deed must conform to the statutory requirements and must show the guardian's authority. Sometimes the guardian must have the consent of the court as well. Trust funds. A guardian, like a trustee, has no right to mingle the ward's funds with his own in a bank account. But if he does this, the law is on the side of the ward and looks upon it as a trust fund which the ward can follow and claim wherever he can find it. This includes the original property or any that has been substituted. There have been a great many decisions involving the misappropriation of funds, and some courts have held that if the guardian acted in good faith and only intended to benefit the ward by putting money in his own name, he should not be held responsible. If the trust fund happens to be real property, formerly the guardian could not buy it from the ward. This is an application of the principle that an agent cannot purchase the principal's property for himself, for there is an implication that the chance for fraud is great. At the present time, these transactions are voidable and dependent upon the action of the infant upon reaching majority, when he can enforce his rights. The court does not look upon gifts from the ward to the guardian with favor, because there is a presumption of undue influence, though it is possible to show that the gift was voluntary. Termination of guardianship. The court has the power to remove a guardian for any one of several causes which show bad faith or neglect of duty in the management of the estate and are contrary to the interests of the ward. The guardianship is terminated by the death of either the guardian or the ward, by the ward reaching majority, by the marriage of a female ward, and, in some states, by the marriage of a female guardian, and, finally, by the removal of the guardian by the court, or by resignation for a reason which the court will accept. A court always requires a final accounting when the guardianship terminates, and many courts in the United States government require a yearly accounting. Very often the court passes the yearly accounts because there is no one to question them, as the ward is not of sufficient age and discretion to do so. If the ward, on attaining his majority, discovers that his guardian has neglected his interests or acted in a fraudulent manner in administering the trust, he can apply to the proper court to have the account opened and re-examined. Apprenticeship. In England, there was another group of persons, usually minors, who were bound under a relationship which in some ways was similar to guardianship and was included in the group of family relationships, together with husband and wife, and guardian and ward. This was apprenticeship, but it can no longer be considered a family relationship, as the character of the master and servant relation has changed from one of status to one of contract, due to the changes in the economic and social conditions which caused it to develop. Before there was manufacturing on a large scale, the necessary trades and arts were carried on by skilled artisans, either in their own homes or in small shops, and children were apprenticed to masters who could teach them a trade. The apprentice served the master, who was entitled to any money which the apprentice earned while working for others during the apprenticeship, and in return the master gave maintenance and training. Statutes in most states provide for apprenticeship and prescribe a method of binding out, either by the parent or by a public official, such as the overseer of poor or selectmen, if the father is dead, though the original purpose was to provide a useful trade for a minor if he could not obtain this otherwise. The developments in modern life have made this type of training unnecessary and undesirable, and apprenticeship is not practiced very generally. Both relationships carry with them a responsibility and should not be entered into without consideration of the obligation involved, or without determination to fulfill the trust.